All right. So what happens when a tenant is consistently late on rent, but refuses to pay the lease mandated late fee? Can that renter be evicted? And then how about if a landlord using RUBS, which is ratio utility billing services, and the renter doesn't pay their portion of the utility bill? Can they be evicted for that? We're going to cover that. Plus, LA County extended their price gouging protections. What does that mean for landlords and renters? We're going to be explaining some of the most confusing and important updates for California housing. Plus, we're going to take your live questions about leases, evictions, everything in between. Hey there, Christian Walsh, real estate agent with Wire Associates, helping renters and landlords understand their rights before things go wrong. So without further ado, let's get Zach in here. Zach, come on in. There he is, looking handsome as ever. Good to see you, my friend. Kenny's going to be here too, but he's having a bit of tech support. And speaking of tech support issue, I might freeze on you. For whatever reason, I keep freezing. If I freeze, just Zach's going to stretch. He's going to make something up. He's going to keep it rolling. Kenny looks like he's almost ready, and then he disappeared. And then he's back. I'm going to bring him on in a minute. Kenny, you stay put over there. Don't do anything wrong. So, Zach, welcome. Good to see you. I have some big news. This is actually my 50th live stream.
Wow.
Isn't that friggin' crazy? And this is our 18th live stream together with California Property Law Group. So I'm going to give us a little air horn. Hold on. Yeah. All right, let's see. Kenny, are you ready to come in? You ready, Kenny? Can't hear you, bud. Keep doing tech support. And unmute yourself. All right. So, Zach, how's the daylight savings time thing treating you?
That's right. Not so bad. Happy to see the Dodgers win. So that was quite the game 7. Yeah. And been getting more sleep since daylight savings time, but been hard at work when I'm not watching the World Series.
I know there's so many sports right now because we had the Dodgers in the World Series and we got football going on and basketball, I guess, is starting. I don't know. I don't watch
Soon the
all these.
World Cup. Yeah, pretty soon the World Cup.
World Cup. All right, so we're going to cover a lot of ground today. A couple important things. Michelle's in the background keeping things clean, so post your comments and questions. This is a live Q&A. We need questions to give you answers. And remember, I can't give tax or legal advice. You can get legal advice from the guys in the ties. They can give legal advice. I can't. The guy in the polo and a hat can't. Kenny, I'm bringing you in. You ready?
Yeah, can you hear me now?
There he is. Here, hold on. It wouldn't be the same without the round of applause, Kenny. Okay, so welcome, guys. Glad you're here. We already got people posting. This is good. We got some questions coming in. Wanted to talk about LA County. So they extended the price gouging protections to November 28th. And this is just a holdover from the fires. The statewide mandate due to the fires, emergency mandate is over, but locally they've continued to extend that. Any thoughts on that, guys?
Yeah, so be careful with that. So really, you have to remember you're only allowed to raise the rent by 10% in all of LA County. That applies even if it's a brand new renter. So don't fall into the trap of thinking that because it's a new renter, you get vacancy decontrol. It doesn't apply during states of emergency. Even if the unit has never been rented, you're looking for 160% of the area's fair market value. You look that up online. The Department for Housing and Urban Development publishes a list of values for each zip code. And then just because they say that they're going to end it at the end of the month, this is really like the 12th of never. These kinds of extensions tend to run for years. So I believe San Francisco, when dealing with wildfires, kept their state of emergency extended for, like I said, years. So yeah, just be mindful of that when you're calculating rent increases and things of that nature.
Yeah,
Kenny,
just to add on
anything
to that, yeah, I think one of the things that I really want to caution people about is giving bad rent increases, even if your intention obviously wasn't to give a bad rent increase. Because weirdly enough, and unfortunately, Bad rent increases are one of those situations where, weirdly enough, there is no statute of limitations as to when somebody can actually bring that up in a case for, say, an eviction. And evictions, as everyone is aware by now, follows what's called strict compliance. And one of the things is that if you overstate the amount of rent that's owed, the landlord will lose the case. And so if you gave a bad rent increase because of these moratoriums, because of these anti-gouging statutes, and let's say 5 years down the road, you have to do an eviction. Let's say for the 5 years, the tenant said, you know what, I had no problem paying the rent. I've been paying the rent. All of a sudden, they fall in hard times. You have to do an eviction. In the eviction itself, they bring up the fact that 5 years ago, you gave a bad rent increase. Well, under normal other situations, there's this thing called statute of limitations. Weirdly enough, for bad rent increases, it doesn't work that way. So there have been many cases where we have talked about rent increases that were bad 5, 7, 8 years ago. And a lot of the times, the landlord doesn't have the documentation to prove that they either mailed out the rent notice, rent increase, or they can't explain how they got to that number. And so essentially, that creates a nightmare scenario where the landlord has to prove how they legitimately got to that figure, and they just simply can't. And that leads to a lot of evictions that are harder for the landlord to prove their case in chief when it's such a simple rent case. And I've heard this quite often where the defense or the point that a lot of landlords bring up is, well, they've been paying it for the past year, they've been paying it for the past 5 years, and they haven't said anything about it. Again, legally speaking, they can't waive that away. And obviously, they're going to bring that as a defense or tenants will bring that as a defense when it benefits them to do so. So you have to be very careful with these rent increases. You should always be consulting with an attorney like ourselves to see if your rent increase is valid, because it may not be a problem for you now. It may not be a problem for you next month, next year. But in the event that there is an eviction, or in the event you have to enforce your property rights, you may run into an issue.
So that's funny what you said. Like, if a landlord tries to use that as a defense, well, they've been paying it for 5 years and didn't complain. You've essentially just admitted that you've been doing the wrong thing for 5 years. So that's not gonna help you to admit that. The other problem you have is a bad rent increase, and then on top of 5 years ago, and then you give an additional rent increases on top of that. You may have given more bad increases on top of that without realizing it because of the first original one. And this for RSO properties, the rent stabilization ordinance, obviously you don't have to worry about it because that's much lower than 10%. For properties subject to the Tenant Protection Act, it's 8% for LA, so you don't have to worry about it there. You can't break this law. But as Zach stated, where people are getting in trouble, it's when the renter moves out and you want to increase the rent. That's one of the biggest issues. So from day one with a new renter, you could be putting yourself in trouble. All right, so All-Nighter, he's here. Good to see you, All-Nighter. Thanks for coming out, bud. He's had bad internet, too. I think it's China hacking us again. He says, smoke the like Cheech and Chong. And we missed a sport. Apparently, ice hockey we forgot. So go Kings. So that is big news on the extension of that emergency protections. And it's for the entire county, so sometimes stuff just applies to LA City or just unincorporated areas, but this is the whole county. So anything in the county this applies to. Okay. So I got some questions that came from a client of mine. We're going to call her Carol to protect her identity. So she uses RUBS, which is Ratio Utility Billing Services, through a company called Livable for utility billing. It happens to be a non-RSO property, so this is in an area where you don't have to worry about the rent stabilization ordinance. She has a tenant who refuses to pay the bill that she's given them. Can a renter be evicted for not paying their utility bill under RUBS? Let me know. I need to know this one. Go ahead, Zach.
Yeah, they can. I mean, so essentially, if you have a contract with the tenant and they promise to make a payment, it could be utilities or all sorts of things, gardening, maintaining the, say the pool, something like that. That'll come up a lot in LA. Any kind of agreement that you have that's not for the payment of, let's say, rent, but is part of the rental agreement. you can give them a notice to perform that covenant or condition of the lease. Otherwise, they have to quit the property. For within LA City, or I should say that different jurisdictions have different rules about that. In unincorporated LA County, you'd have to give them a 10-day notice. In Santa Monica, you'd have to give them a reasonable opportunity to cure. In places where you're covered by the statewide Tenant Protection Act, you have to give them 2 notices, a 3-day performer quit, followed by a 3-day quit. So the procedure can vary slightly from jurisdiction to jurisdiction, but by and large, yeah, if they make a promise in the lease agreement and they break that promise, then you can do an eviction after you give them a notice and they don't comply with the notice.
Yeah, I'm going to encourage Carol to call you guys to help, because assuming they don't, and so it's a Tenant Protection Act property. So first she'd give the notice to cure or quit, then the notice to quit. Assuming that the renter doesn't quit or pay, then it becomes a standard unlawful detainer action, correct?
Yeah, that's exactly right. And so you need to give them an opportunity to sort of fix the problem. Here would just be the payment of money, and then going forward, continuing to make those payments. But if they don't do that, then you can maintain an eviction. Now, you also want to be careful and make sure that you understand what's in your lease and what exactly they're required to do. I can't tell you how many times landlords have come to us and they only have sort of a vague vibes-based idea of what the lease says, right? Which is, sort of they're responsible for utilities, let's say. And come to find out that the lease has a very intricate and detailed procedure for the presentment of a bill and the time to dispute. Make sure that you know what you're standing on before you go and sort of make a fool of yourself by telling the tenant to pay a bill that they might not actually owe. So go double check your lease, make sure it says in black and white that they need to pay those charges. And if they do, you can feel assured to give them a 3-day notice to perform or quit.
Okay, and then there's a little twist in this one. So Carol has 2 separate leases for one unit. One is a lease for the unit itself, and then there's also a lease for the garage. So I'm assuming, I don't know for sure, but I'm assuming that she put the RUBS agreement into the lease for the unit. So would she give 2 notices to cure or quit, or just for the rental unit itself, not the garage? Thoughts on that, guys?
Anywhere that you want basically anywhere where there's someone living, if it's sort of separate from another place where someone else is living, you want to have a separate eviction. So if there's no one living in the garage, if it's just being used as a garage, then there's not going to be an issue. It doesn't have a separate address. It's not a separate unit for the postal service. It's just a garage. It's an amenity. With that being said, if you have, let's say, a separate ADU and you're renting both to the same family with 2 different leases, then you might want to, if it has a separate mailing address, if it's totally detached and somebody can spend the night there, maybe it's got a bathroom. Now, essentially, you're talking about the types of things that the sheriff is likely to put up a fight about. Because if the sheriff is going to a unit that says 123 Oak Street, and you're telling the sheriff to do an eviction on an ADU, which does not say 123 Oak Street, the sheriff might have a hard time doing that. But if the garage is attached, it's being used as a garage, it's not being used for somebody to live there, you're in a much better scenario, and you should be okay just doing, and if it doesn't have its own separate mailing address, you should be okay to just do an eviction for the parcel and not too
good. Very good advice. I appreciate that. We're going to actually talk about late fees next, but let's get to a question from Christopher. Kenny, this one's for you. So in Northern California, I rent by the room. I have a tenant that passed away last month where the daughter lives in the property in another room. So we have a tenant in one room and the daughter in the other. How can I handle having the room cleared for another tenant to move in November? So this sounds like you have a death, lease is over. What should a landlord do next when somebody passes away in a property, even if it's just a bedroom or if they occupy a whole rental unit? Advice.
So this is notwithstanding the fact that there might be local jurisdictions that apply for the kind of eviction that you'd bring forward if you were to take possession of the entire unit back from not only the daughter but from anyone else that's in the unit itself. But essentially, if let's say this, for example, you were in the jurisdiction of LA, there is what we kindly refer to as what's called just a dead notice, where essentially if the lessee or the lessee was the one that had passed away and the other individual was taking under that contract, you could serve a 3-day quit notice onto that individual and do an eviction that way. I can't speak necessarily for the Northern California jurisdiction that you would be in. So depending on that jurisdiction, they may have a different rule. And again, this is part of the reason why it can get a little bit convoluted, is because depending on what county you're in, what city you're in, you may have completely separate rules in terms of what just cause protections are. But I can speak specifically for LA City. In the event that an individual that was the tenant does pass away, and anybody else that would take under that contract, you could serve a 3-day quit notice upon them for RSO units as well. Now, you're going to run into situations where there probably are going to be what's called arietta claimants, or people that come in the lawsuit and want to insert themselves into the lawsuit because they had a previous claim from an independent source. But you can address that in the eviction case itself. But yeah, I would really want to know first and foremost what local jurisdiction you are in for me to better adequately answer that particular question. But generally speaking, you could serve a 3-day quit notice on those.
Anything to add to that, Zach, on the death of a renter?
Yeah, just a couple things. I mean, I think Kenny hit the main points. I think basically Civil Code 1934 says that the hiring of a thing terminates upon notice to the other party of their death or inability to contract. So once you have noticed that the renter has passed away, that terminates the contract. There's a case called Miller and Detsatnik versus Bullock from 1990, which talks about sort of the procedure for what to do when someone has a unit and passes away. Basically, what they said is that the person, if they've paid for the month, you shouldn't rent it out within the month, and then let the family come and collect the things. I would itemize the things that remain in the property with a notice of right to reclaim abandoned property. Itemize the security deposit and probably send it to either their, let's say, next of kin, or if they have a trust, or if they're probating a will. You try and figure out who the correct person to send that to would be. If you can't figure out who it is supposed to be, it's a process called interpleader that we kind of won't really get into, but that's what you would do. And yeah, basically, if somebody, and this happens quite frequently, if somebody comes and stays in that unit, you would be surprised and amazed how many times people come and, let's say, a family member's died, they have a low rent unit, somebody comes in and says that they're moving stuff out, but really they're moving their stuff in. Number one, don't take rent from anyone for that unit, okay? Number two, don't take rent from anyone for that unit. And if you, number three, are going to take rent from someone for that unit, you really want to look at Civil Code 1947.3, which allows you to have a statement that says, I'm going to pay the rent for this, but I'm not going to become a tenant. Here, I would never recommend doing that. Some landlords, they say, well, if it's going to take you a month to get the stuff out, because sometimes it takes time to remove the belongings. Well, I want somebody to pay me rent for that month. You may have just gotten yourself a brand new tenant until they die. So yeah, really, really, really do not accept rent for that period. If you find anybody who's there, you can give a 3-day notice to pay rent or quit, and go check out the case Miller and Detsatnik versus Bullock.
Of course, you'd have case law to cite. That's what you do, Zach.
So my name's Miller. My name's Zach Miller. So
that's why you remember.
My heart, yeah.
Any case with a Miller in it, you remember. That's good. That's a good mnemonic device. So from the real estate side of things, if someone does pass away in the unit, please note that you have to disclose that to the next renter. You have 3 years, so you have to disclose that. If it's natural causes, if it's a violent death, so it's a murder, or potentially even a suicide, that may be something that you have to disclose indefinitely. So bear that in mind as well. All right, so let's dive into late fees, because things have changed with late fees. Like during COVID, you couldn't collect them, blah, blah, blah. But let's talk right now. So if you have a tenant who refuses to pay late fees on their rent, so they still pay their rent late, but they don't want to pay any sort of late fee, what do you do in that case with that renter? What would be your advice?
So it really just depends on if you're looking to do an eviction or you're trying to work it out with them. The real issue when it comes to late fees, if that's the only cause of action for, let's say, an eviction that you want to take out against a tenant, is really going to be the materiality of it, as well as whether or not the late fees are going to be seen as what's called liquidated damages. Because essentially the court may not want to enforce that for an eviction purpose and find that it's not material for the purpose of the rental unit itself. So you have quite a big mountain to climb if your only cause of action or the only reason why you're bringing an eviction is for a late fee situation. That's not to say that they don't owe the late fees if the lease agreement calls for it. But the weird kind of intricacies for evictions is that you're asking the courts to give you possession of a unit back, and there's drawbacks for that. And a part of that is the strict compliance regimen that we were talking about before. And when it comes to the materiality of it, that's going to sway more on the tenant side. So again, I would be somewhat wary if a landlord said, I want to evict somebody because they're not paying the late fees on a specific issue or a specific fee that was associated with their tenancy. That's not to say that you can't win on them. You could, but the likelihood of success on those is fairly low in my opinion. If you wanted to collect on those late fees, you're probably better served by filing a small claims action specifically for the late fee violation that they haven't paid. And you'd have to point out in the lease agreement where and how they violated that lease agreement in that action.
That's good advice. And another important point, so you can't take the rent for a future month and apply it to those late fees. Like rent can only cover rent, correct? Does that question make sense? I hope that makes sense. Like you can't, like let's say the rent's $1,000, the late fee is $100, and they didn't pay for October. They pay in November their $1,000. You can't not apply that all towards that back rent, correct? If they owe back rent. Am I making any sense?
No, I get you. So,
I need more coffee. I know it's end of the day, but still, I need more.
so you'll
And
want
it is coffee.
you'll want to check out Code of Civil Procedure 1479. I'm pretty sure it is. Basically, there's a kind of dance to it. So if you have multiple obligations, right here we've got the obligation to pay the rent, we have an obligation to pay a late fee. If you have multiple obligations and you express your intent that performance, here a sum of money, be applied to any one of them in particular, the creditor has to honor that intent. So if you, for example, tendered a check that was in the amount of $1,000 and it said $100 in late fees and $900 in rent, that's how the landlord has to do it. If it says for rent, that's how the landlord has to do it. If you don't, if you just tender a check, then it switches to the landlord, who can essentially dealer's choice apply it to whatever's outstanding. And then finally, there's a default rule in the case where nobody makes any election whatsoever as to how to apply it. And it's usually to the oldest debts first, secured debts before unsecured debts, and so on. Then things having like a lower interest against, or things having a higher interest against things having a lower interest. There's a procedure by which you can calculate what it should be applied to. But yeah, it is very common that people will pay and put on their rent March 2025, and then your hands are tied. But if they don't do that, then you could make an argument that you applied it first to the late fee, and now there's unpaid, let's say $100 in rent, because $100 went to the late fee. The problem is that when you go to trial, people are going to see $1,000 rent comes due, tenant pays $1,000, $100 late fee comes due, your 3-day rent notice is asking for $100, so you're going to say that's $100 in late fees because 100 matches 100. That's tough to overcome, right? You can see that the fungibility of money works just as much for you as against you. But there's nothing wrong as long as you follow the procedure. I think it's 1479. As long as you follow that, you're fine.
Okay. Now, just to layer this in, that this is again a question from Carol. So that same renter who's not paying his RUBS bill is also not paying the late fee. So would Carol, should she mix together that notice to cure or quit with late fees, or just keep those two items separate so that it doesn't kill it?
I hate late fee cases, to tell you the truth.
Good summary.
I think late fee cases just you have the problem is that there is a presumption against liquidated damages in contracts that are for residential real property. So if you go to the grocery store and buy a candy bar and the contract says that if you don't pay on time, we have late fees, that's fine. But or I think that's fine. But for leases, all late fees are presumptively bad. So you have to show that the late fees are sort of a reasonable estimate of a difficult to approximate figure for the cost that it takes to process the late payments. People will very often just set them as a percentage of the rent. So if you're late, you owe me 5% of the rent. This is not a great way to do it. So I think if you can, avoid late fees with a 20-foot pole.
No, that's good advice. I like that. Kenny, did you want to add to that?
Yeah. So essentially, as long as you keep a clear record about what you're applying it to, you can then, bring forward the latest bill or invoice or ledger that shows, hey, you paid 1,000 in, let's say, November of this year, but you actually owed rent since there's actually been another bill that you owed, let's say for 2024 in December. I'm applying it for that month. You still owe November's rent. But the real issue is, again, you need to be very careful here, because in the event that they pay you for that month and they tell you, hey, look, this is for November's rent for this year, you cannot unilaterally say, well, you also owe me for last year, so you still owe me this year. You do that, you will lose. You will lose every case you bring forward. So you need to be very careful when you do that, where if the tenant doesn't, or if the tenant does say what this payment is for, you can't just unilaterally apply to something else. So with the late fees, with the RUB scenario, if they're paying you money and they don't tell you where it's supposed to go for, you can apply for any of those bills as you like, but just make sure that you are being clear in terms of how you're applying it. Because when it comes to the presentation of your case, if you can't even explain how you applied the money, there's no way that anyone that's going to be determining if you did it correctly or not is going to understand the scenario. I can't tell you how many ledgers I've seen where I get presented the ledger and the landlord can't tell me how they came up with the figure. And that's not going to help anybody. It's not going to help the juror. It's not going to help the judge. It's not going to help you. It's not going to help anybody. So you need to make sure that you can explain what's going on, because you are the one that's presenting the case forward. And we can help get you there, but the facts are what the facts are. And in presenting them is going to be a hurdle in and of itself for some landlords.
That's great advice. Yeah, it's not a good start if you can't get your math to math up. You don't want to try and solve that in front of the judge. All right, so we're going to jump into some questions here. So Sammer, your comment got cut off. I've talked to Sammer before. He's got a Tenant Protection Act multifamily property. He's got a permit to do a substantial renovation for stairs. So Sammer, give us the rest of that question there. And then we got an update. This is a long one. This is quick update about the situation we talked about before. So there was the abusive building manager and a harassment lawsuit that the tenants filed against the owner. Plus the manager got looped in. So tenant one pressed charges against the manager for battery. The manager's in jail. That's good. Tenant one was assaulted again, this time by a new tenant. It was the second time. Holy cow. What's going on in this building? It's probably time to sell this building. Just going to throw that out there. There's a CCTV footage confirming the assault and battery. Tenant one pressed charges against the new tenant as well. First assault happened on the property, the second 50 yards away. Let's see. Footage is only for the second incident, 50 yards away. Okay, so no proof on that other one. This is like a Netflix crime drama. So now what? What happens next? How much can I lose or be held liable for these assaults by my manager and new tenant on a longtime tenant who's in good standing? Can a manager be liable for tenants that are beating other people up? I know we talked about the manager. There may be some liability, but what about renters?
So landlords do have what's known as an implied covenant of quiet enjoyment that's owed for all tenants that you rent out to. What that means is that basically when you rent out a property, the landlord actually has an obligation to provide the use of the property for what they're saying you can use it for. So if the idea is that you're going to live in there, and the landlord is contributing or neglecting to actually take care of the obligation to restrict nuisances, restrict people's access so that they don't harm the tenant's ability to use the property, that's an obligation and a liability that the landlord will incur. Now, with the property manager that the landlord put in, that's a direct link. And you could absolutely be found liable for that because you're the one that put the manager in there. So the liability can be quite huge on that end. But the liability also doesn't just end off of, well, it wasn't me that did it. It wasn't the person that I put in that did it. It could be anything that is interfering with that tenant's ability to use the property, because that could be a violation of the covenant of quiet enjoyment. And that's going to be something that the tenant would have to bring forward as an affirmative case or a affirmative lawsuit against the landlord. And the damages can range. It can range quite heavily. It could be a couple thousand to hundreds of thousands. It just depends on what the actual damages are and the circumstances of the case itself.
Yeah, your advice last time was talk to the insurance company. I remember that. Zach, what were you going to add to this?
Oh, this sounds like the old joke where the kid in a divorce, we're going to award custody to the mom. No, the mom beats me. Okay, how about the dad? No, the dad beats me. The grandparents? No, they beat me. The aunt beats me. Uncle, they beat me. They finally say to the kid, well, where do you want to go? He says, I want to go with the New York Jets because they can't beat anybody.
I was wondering where you headed with this. You are funny. Hey, we got a bunch of New York Jets fans that are angry now. I'm sure we got a ton tuned in. So all-nighter's solution, he thinks that it's the tenant one is the troublemaker because they're in several different incidents. So maybe you can do a no-fault termination there. That's all-nighters advice. So Sammer's asking about the deadline for collecting of late COVID rent. That's COVID debt. Technically, it's not rent. They waved their wand and turned it from rent to COVID debt. So is that over? Can people still collect that? I'm trying to remember. You have to go to small claims court. I know that, but I don't remember what the deadline was.
So you would have 4-year statute of limitations for failing to pay on a written contract, 2-year, I think, for an oral contract. So presumably then there's also for some old debts, you might be running, there was a period of time where the courts were closed. So everybody's statute of limitations got extended by, I think, about 6 months.
Yeah.
But you're probably running into
getting close to a deadline of some sort.
Unless you're in, like, let's say, an area where, like, for example, LA City, which had its own moratorium. If you're in Riverside and you're looking to go after COVID debt, a lot of that debt is now, let's say, past the statute of limitations.
And don't think that because Zach and Kenny don't know a definitive answer, they don't know what they're talking about. They can't help you because it had to be done in small claims court. That's what the law specified for COVID rental debt. Is as a landlord, you could recover it, but you had to go to small claims court, and these guys can't help you in small claims court. So that is basically the issue there. And they lifted the limits. It wasn't the usual small claims court limits. You could go after whatever legitimate debt. But anyway, they
The,
can't
the
help.
issue the issue with that, just adding on to that a little bit, was for particularly for evictions, and a lot of landlords don't realize this, is that you're only allowed to for a rent notice only go back 12 months.
Yeah.
And I think a big part of that, when the legislature kind of was drafting these laws, thought there's no one in their right mind that would wait a year to then be like, oh, my tenant owes me money. Let me ask for them to pay the rent. So they thought, well, 12 months might be a good number to kind of cap it at. Weirdly enough, there's many landlords who don't ask for the rent for more than a year. Also, you had COVID, which added a lot of crazy timelines. But yeah, the thing of it is that if you're looking at a debt that's more than a year old, you're probably outside of the realm of an eviction territory, and you're more within the realm of a breach of contract, either in a small claims case or in a regular civil case, where you're not going to be able to do an eviction over it. That's not to say, again, that the tenant doesn't owe you the money. It's just that you wouldn't be able to evict them over it.
So, barring a national disaster like COVID, the lesson in this is do not wait a year. Call California Property Law Group as soon as they miss their darn rent, and basically get these guys on the phone and get them issuing 3-day notices for you. That's what I say to that. Okay, so we're circling back to the renter who passed away, living in one bedroom. The daughter lives in another bedroom. And the follow-up question is, what if the property manager accepted rent from the daughter? So I'm gonna obviously let the experts talk, but it sounds like there was a lease with the dad only, because otherwise this would be moot. Because if you had a lease with the daughter that was separate, the fact that the dad passed away doesn't matter. And then the other important thing is, what the heck are you doing? Why is your property manager doing stuff like this without talking to you first? So anyway, does that sound about right, guys? It sounds like there was a lease with the dad and not the daughter. Go ahead, jump in.
That's really why you want to get those Civil Code 1947.3, let's say, notices. Essentially, if you're not required to take a payment from anyone other than the person who's on the lease. And if someone wants to tender a payment to you, you can require them to say, I'm not a tenant here, this does not create a tenancy, and sign it. And then you can have that be, you don't need to have them do that every time. You can have that be just one and done. Okay, they're not your tenant for as long as they're paying you. That's on behalf of somebody else. It doesn't create a tenancy. So that is something that you really want to do. This can happen a lot with people who will get checks in a rent box. They'll find payments that, it says what unit it's for, but it's from somebody else. You really want to be careful, because if you go to court, let's say you want to change the locks, the court will see the daughter is paying, and maybe the daughter for a time was living there. So they see somebody who's at the property making payments to the landlord starting to look a lot like an oral lease agreement or an oral contract. So that's why, to be very safe, you want to get in black and white the form language from Civil Code 1947.3 that says, the child is not a tenant.
That's good. And let me remind you, landlords, that the property manager with an agency agreement is you're in trouble for whatever they do. You're responsible. When they're acting as your agent, that's you. So be very careful who you hire. So let's go back. So the tenant who was in the two different incidents, Mai says there's never been a problem in all the years the tenants lived there. So it's not the tenant. It's just unfortunate incidents that have happened. So thanks for sharing that. We want to be fair to people. I know we can kind of joke and jest, but let's be fair. So moving on, more questions. Okay. So if I live in my ADU for 3 years as my primary residence, this is a tax question. These guys aren't going to know this one. Do I qualify for the Section 121 exclusion, 250 tax free? Yeah, the short answer is you do, for the portion of the ADU. So basically, you're going to talk to your tax advisor, and if the house is worth 70% of the value and the ADU is 30%, you are going to get Section 121 for the ADU. You may get both if you actually lived in that house for 2 years, then moved into the ADU. But anyway, long story short, you're going to talk to your CPA. You can do a 1031 exchange and a Section 121 exclusion on the same property if you have an ADU. We can talk offline about that. I've helped clients do that. Okay, so what are you guys seeing right now as far as unlawful detainer actions? How are the courts doing? I know we've got the Tenant Right to Counsel Act, and you guys don't know if a renter has received an attorney, but are you seeing more attorneys? Are you seeing things taking longer? Let me know what you see out there. Zach?
Well, so yeah, it's sort of early. I mean, I think that the trend was ticking upwards for people to be represented. I do think that still you're going to see a much higher percentage of representation close to downtown LA. The further away you get, the less likely you are to see pro bono firms taking on cases. So if you go out towards Long Beach, Norwalk, Antelope Valley, you're less likely to see like legal aid type attorneys there. I will say that, yeah, probably on net, the number of attorneys is going up, but not by as much as you might think. Essentially, attorneys don't just come out of, the ether. And so it's going to take time for the program to get ramping up. But yeah, your odds are probably better than you're probably looking at a worse than even chance that the tenant will get a lawyer at some point in the process. Yeah.
That's good to know. Kenny, is that what you're seeing too, bud?
Yeah, so I mean, in terms of representation, we are still seeing somewhat of an upward trend, which is pretty much more or less the goal of the legislation that was passed. But we're not seeing every single case where there is representation as of yet. That probably is the goal of the legislature at a certain point, because their idea is that they think they can fix the housing situation by stopping evictions for whatever reason that I don't know if that's a sound idea.
What if we just had paid the back rent? Wouldn't that solve the problem instead of getting attorneys in there? Anyway.
Well, the government's thought for that is let the taxpayers pay the rent for that one. So those rent relief programs have been they've been drying up. I don't know.
$5,000 per case is the budget for the LA City Right to Counsel Act. That's what they've budgeted for the attorneys. So, and how many of those cases is the rent owed less than $5,000? So not to get all mathy on politicians, but maybe it's a better use of the $5,000 per trial to actually help pay the back rent. And the reason you're not seeing so many yet, sorry, I sometimes have these crazy ideas, but the reason you're still not seeing that many, Zach, is they're phasing it in. I think they have 80 that they hired, and the plan is over the next 5 years, it's certain zip codes too. It's the lowest income zip codes. But yeah, the plan is, like your guys are saying, is eventually have enough attorneys to help out with all those cases. So, but keep going. Sorry, I interrupted, Kenny. You're seeing it out there.
Yeah, so it's definitely an upward trend, and I do think that the goal of the legislature is to see full representation of all cases, kind of like I mentioned before in previous podcasts, where they're looking for basically treating these somewhat similarly to that of criminal cases for representation purposes. But the thing that I wanted to mention is that the attorneys that come forward on these cases come in all shapes and sizes. Some of them will have different motives. Some of them will have different ideas of what defenses to bring forward or how a case should resolve itself. One of the best ways to make sure that the case resolves on the merits and not necessarily unnecessary attorney paperwork is to make sure that you don't allow or have attorney fee provisions on your contracts. Yeah. Because that creates a perverse incentive for.
Let's flesh that out. Sorry to interrupt. Let's flesh that out because that's a very important point. We bring that up. So what Kenny is saying is, in many leases, they may have no cap on attorney's fees, meaning that whoever loses is going to cover the other side's attorney fees. And some landlords who think it's clever are saying, oh, well, then I'm going to win, so I want them to pay for my attorney. But it doesn't always work that way. So what happens is attorneys representing tenants, when they see there's no cap on attorneys' fees, are much more likely to go ahead and represent that tenant and load up the fees because they know they're going to win, and guess who's going to pay it. So that's what Kenny means by perverse incentive. So keep going. I wanted to flesh that out for everybody.
It's like a double-edged sword, right?
Yeah.
Where I get this question a lot, where it says, hey, it says the tenant is going to pay my attorney's fees, so I'm going to take the literal definition of what those words mean and say it only goes one way. Well, welcome to the state of California, where it's double-edged and it goes both ways. So just because it says that it goes one directional, it applies both ways, and it can be a very dangerous thing to have. A real example that I have for this is I have seen attorneys who have had a winning argument, who could have disposed of the case on the first day, waited 6 months to file said motion after doing 6 months of unnecessary work on both sides, and then win the case 6 months down the road, and then ask the court, I want $40,000-$50,000 for the six months of time that I worked on this case. And I've seen some judges who see and understand what's going on ask the question, why did you wait 6 months for this? Why did you do it after 6 months? Now, unfortunately, or fortunately, whichever way you want to view it, the court is required to still give the reasonable attorney's fees for that work. There is discretion in terms of what the judge believes is what reasonable attorney's fees would be. But again, with these attorney fee provisions in these contracts, it creates an incentive for lawyers to not want to resolve cases when they know they have a winning argument in a fast and efficient manner. And it creates drag in our system. It creates a system that can't really sustain itself because people are kind of spinning the wheel, hoping to just get more out of the case when realistically the case should have been over from the day it started. So there is a mechanism that parties can take on to remove those provisions so that you don't have these cases that should just be dismissed, that should start over, or that it is clear that one side is wrong and one side is right. And that's what's known as an 827 notice, where you could just remove that provision or at least put a cap on it so that attorneys are no longer incentivized to keep spinning the wheel, to keep adding on those charges onto the case in hopes that they get a payout down the road after they completed the case.
So, like something like this from your site, 827. You guys have the form on your website. So hopefully you could see that I just popped that up. But yeah, Zach and Kenny and Raphael have given you a lot of great forms. Okay, so is this true or false? Arbitration clauses are a way to avoid litigation and attorney fees. Because I know we've discussed this before, and you don't want an eviction. You don't want the unlawful detainer to go the route of arbitration. You want to run that through the unlawful detainer action. So thoughts on this, guys?
Yeah, so see if you can, how do I put this? You probably want to carve out unlawful detainers from things that go to arbitration. The reason being unlawful detainers are expedited and faster. If you have to do an entire arbitration process, then petition to confirm the arbitrator's award, and then from there get a judgment and go get a writ of possession, that takes a really long time. So instead, most leases exempt from arbitration unlawful detainer, and usually that's not a big issue. I've never seen that be the sole basis on which an arbitration agreement is held to be unconscionable, though you should know that one of the things courts will look at when deciding the conscionability, or the unconscionability rather, of an arbitration agreement is procedural and substantive unfairness. And one of the, let's say, procedural unfairnesses is all of the things that I want to sue you for don't have to go to arbitration, but all the things you want to sue me for, all of those have to go to arbitration. So the more stacked it is in favor of one party, the more likely they are to find unconscionability. So yeah, be careful with that. But if you exempt just unlawful detainers in a residential lease, everything else goes to arbitration, should be fine.
It's
Yeah,
good.
weirdly enough, with arbitration, and I kind of like to do it like a tiered system in my head, is that when we tell people, or when we tell landlords and as well as tenants, that most of these evictions are supposed to resolve themselves somewhere between about 3 to 4 months. 5 months is kind of pushing it. 6 months is what are you doing on the case? And so essentially, if you don't resolve the UD cases or eviction cases within that time period, there's something that needs to be addressed. And the reason why you don't want to arbitrate eviction cases is because arbitration can take longer than that sometimes. But the reason why people prefer arbitration in regular civil lawsuits is because regular civil lawsuits can take years. Arbitration can take a year, maybe 6, 8 months. But the thing of it is that when you have a tiered system, you have eviction UD cases fastest that you will get a trial, and then you have arbitration up there, and then you have regular civil trials. There's regular civil trials, you'll see trial dates come out 2, 3, maybe even 4 years down the road. So that's the reason why arbitration is preferred in those cases, but not for UDs, not for evictions.
No, that's a good distinction. I appreciate you guys mentioning that. And I remember we've had this discussion before, and I'm glad you brought that up, all nighter, because that's an important point. And he says, thanks for the clear up on that. So, Kenny, you mentioned that attorneys for landlords who have no cap on legal fees in the lease will drag things out potentially. What I do want to clarify is you guys representing landlords are not going to drag things out to charge landlords more, correct?
Yeah, so essentially, whenever we have trial dates, whenever we have something coming up with the courts, we will do whatever it takes to get a resolution for the case itself. A somewhat neat little trick that the courts have kind of been feeding into, and some defense attorneys really kind of rely on, is this kind of impromptu idea of first appearance jury trial or first appearance non-jury trial. And what that really means is it's the parties coming to court for the first time. Are the parties going to settle or are they going to do the trial? Well, the judges don't want to do a trial. The jurors don't want to do a trial. The parties don't seem to want to do a trial. So let's push it out for another month and see if you settle. What we like to do is we look at what the tenants did. We look at whether or not in their answer they've perfected their right to a jury trial. And we'll also set it for a jury trial so that we try to avoid this idea of a first appearance jury trial or a first appearance non-jury trial. Because a lot of this kind of inertia that's been built in the court is that no one's going to be doing a trial on their first appearance. We try to stop that. We try to tell the courts trial dates are trial dates. The minute order, the notice of trial doesn't say first appearance jury trial. It doesn't say that at all. It says jury trial. It's the same jury trial as if it was a second one, third one, whatever it is. And we always announce ready for those. We always try to announce ready for those because we want to for the case itself.
Is Kenny freezing or am I freezing?
Yeah, we might have lost Kenny for a minute there.
That's all right. They don't want us to know the truth. They're blocking what Kenny's saying. No, that's good advice. Keep going, Kenny.
Yeah, can you guys hear me now?
Oh, yep, we got you. You're delayed, but keep on spouting wisdom, my friend.
Yeah,
Preach on.
So the thing of it is that we will react to what's going on in the courts. I've seen a lot of other landlord attorneys who do not react and they're set in their ways, which is fine. That's fine. But you're going to get delays from that. You're going to get old methodologies that are being tested because, again, the laws are changing, the procedures are changing, and you are seeing even the courts react. It wasn't about a year ago where we said you're never going to get jury trial assignment because the juries just aren't there. Well, now the courts have reacted and you are getting assignments that are faster. In fact, we got an assignment today for a jury trial where the defense counsel said, hey, I don't think we're ready for trial because we're not going to get an assignment today. I said, you want to bet? Let's go. We got an assignment. So, that's a reaction that that a lot of landlord attorneys need to take more seriously, where we need to actually announce ready for the trial and prosecute the case. And that's what we do. We make sure that we announce ready for cases when we have to.
I love it. And what is this? Things change in the law very recently, like Ashigian versus Cepeda that just changed in June, and you guys were up on that. And in fact, they said they're not going to make a change to that appellate opinion, right, Zach? You followed up. I'm sure you followed up on that.
Yeah, for the Supreme Court, I haven't checked recently. I saw that it was up for there were like a zillion petitions for rehearing, but I have no doubt that they would decline the opportunity to rehear that. The appellate division publishes very few cases per year, maybe one or two. So yeah, this I think is going to be the case of 2025.
Yeah. And what it did is it changed 3-day notices and notices, making sure that the renter understands if they receive a 3-day pay or quit when 3 days starts or ends. So, and that means a lot of, if a landlord isn't up to date on that and using an attorney who's up to date on that, they may be giving invalid notices, which are no fun to find out in front of the judge that that's an invalid notice.
Yeah, that case is going to invalidate a lot of notices, and a lot of people are going to find out the hard way.
Yeah, but not if they hire a California Property Law Group, because you guys are going to do it right. Okay, so we're running out of time. What is this? This goes by so fast. I love this. This is a great question from Mai, and we're going to have to talk about this. I actually should release a video. So the question is, which cities in LA County would you recommend landlords buy multifamily properties based on your experience with eviction and rights for landlords? So the first place I'd say in LA to buy multifamily is Orange County, which means don't buy in LA. No, I'm just kidding. There are spots. So there's certain spots that don't have any special protections. They tend to be the incorporated areas like Torrance, for example, Hawthorne. I have a listing coming in Hawthorne. But then there's some gotchas like Lawndale. Lawndale doesn't have any special protections for properties, just Tenant Protection Act, but they have a lovely pre-sale inspection report requirement that you have to bring your property up to code, even if 2 or 3 previous owners before you did everything wrong. So anyway, long story short, if you guys want to give a quick thought on a spot where you guys either have good luck or things move quickly, and then we'll add to this later on at some point in time. Go ahead,
Yeah,
Ken.
so usually courthouses, there's general UD hubs or eviction hubs. If you're looking for, if you ever need to go through an eviction, you're probably looking at a more friendly court the further away you go from downtown. That's probably where you're going to be getting an easier time, just because there are more evictions in downtown. Their case numbers are a lot higher. There's a lot more congestion. There's more, quite frankly, just people there. So you're not going to get the kind of service or the kind of level of attention that you might get in other outward areas just because of the sheer volume. So the further out you get from the congested areas, probably the better from the more concentrated areas at this point.
Zach, any spots that pop into your head?
You can look for places that have carbon copies of statewide rent control. Essentially, you're going to be, as a multifamily, likely going to be under statewide. Long Beach has a carbon copy.
Yep.
So it's not really that much different. Inglewood, likewise. Those places.
Yeah, Long Beach has slightly higher relocation assistance in some cases, but yeah, other than that, it's not much different. Yeah, and I was only half joking when I said Orange County is the best spot to buy in LA County. It's like, look outside. San Bernardino, Riverside, they don't have special protections in those areas, so look around. San Diego does, LA, lots of pockets.
But there's no place that's safe now. I mean, even Burbank is considering passing their own version.
100%.
It's, renters protection is going to be, it's here to stay. Whether you like it or not, it's here to stay. And depending on if it's going to catch on fire for other cities in your jurisdictions, I think it's just going to inevitably happen.
Be careful with that analogy, by the way. Because that does remind us that LA County, anywhere in LA County, even the incorporated areas like Torrance or Long Beach, you're still under the emergency protections from the fires. So you can't, you've got price gouging laws in place. Okay.
Yeah.
So let's talk about you guys. So I find myself skeptical when I talk to other real estate agents who specialize in everything, like they say, oh, yeah, I do commercial, I do multifamily, I do single family, I sell all over the world. I feel the same thing about attorneys. So when I talk to attorneys who do eviction, do business, do family law, do, I don't know, medical malpractice law, like if one attorney is doing all this stuff, I'm very skeptical because it's a full-time job to be an eviction attorney, just that one vein. So do you guys feel the same way? Are you skeptical? Are you how about this? Are you excited if the person on the other side is a multi-hyphenate attorney?
Yeah, so generally speaking, people that dabble in specific fields of law generally do not fare too well if they just kind of come in one time and say, "Listen, let me try this out." I guess an example that you can give is if you had an issue with your foot, you wouldn't want like a brain surgeon to come and be like, "Let me diagnose your foot problem," right? You want to go to a foot doctor instead.
Yeah.
Same can be
It's
said
even
for
worse the
attorneys.
other way, for the record. It's even worse. If you got a brain issue, you go to a foot doctor. But anyway, sorry.
So the same, I've seen the same kind of situation with attorneys who are doing evictions, where I have seen, there's individuals who have their attorney who they handle with everything in terms of all their transactions, and they say, I have this one off where I have to do an eviction, and I've seen that attorney on that same case, five, six, seventh eviction, and that attorney is learning every single time what to do next. So yeah, when it comes to the specialization of evictions, it can be treated just like any other field of law, where if you're not in it, if you're not specialized in it, you're going to make mistakes. And the person that's going to be paying for it is not the attorney, it's going to be the client, it's going to be the landlord that's going to be paying for those mistakes.
Zach, you are like a super specialist. Like you cite case law and all that. Like, do you have the bandwidth to be a specialist in 10 different kinds of law? Be honest. If you do, I would believe it, but
No, yeah, so that's the thing. I mean, there's a pretty big, not infinite, but a pretty large body of specialized technical law for unlawful detainers, which you really have to work at to develop. Yeah, for mom and pops who it's their first eviction, maybe ever, or maybe in, let's say, 10 years, they stand no chance going up against someone who does it day in, day out. I mean, they just really don't. Particularly because I think that so many landlords work off of the basic assumption that if the tenant doesn't pay the rent, everything else follows from that. That's not at all the case. You need to think of it as, did I do every single solitary thing correctly, right? From beginning to end over the course of maybe, the entirety of the tenancy, 10, 15 years. If anything in that process was incorrect, you're going to need legal assistance, right? If you didn't post the correct notice, if the rent increase wasn't served properly, if you didn't realize that there was some new case or some new law or some new this or that. That's why attorneys are so important, right? The kinds of mistakes that these mom and pop landlords would make, we've made before and have already learned from. We're just kind of further down the same path that they'd walked.
or seen other attorneys make those mistakes and learn from. You guys have shared some of those stories where you see goofballs doing silly things.
Yeah, exactly. Like Jurassic Park, right? Learn from our mistakes. Now we're making all new ones. So yeah.
Why do they keep going back to Jurassic Park? That's a whole other discussion. But anyway.
Money is the real answer. But yeah, the thing is that we provide a level of expertise, background knowledge and expertise that I really wouldn't feel comfortable recommending anybody else who wasn't a specialist to even attempt one of these cases. It's just not something that's easy, and you really don't. There's nothing more expensive than an attorney that can't get the job done.
Well, and you guys absolutely can get the job done. You're my favorites. You're my number ones for Southern California. I keep trying to get you into other counties and other places. Like you guys are absolute experts. I appreciate you being here. This was our 18th show. Great work, you guys. Let's keep them rolling. Let's get Raphael back on here and Christina. It would be great to have her back. She did one. We scared her. But no, thank you guys very much for doing this. It's been over an hour. I appreciate you guys giving your very valuable time and feedback and answers. I can't thank you enough. So All right. So make sure any issue you have as a landlord with a renter, reach out to California Property Law Group. For renters who are having issues, make sure you reach out to legal aid in your city and or county. And all-nighter, you have of course, you have another question right at the end. Reach out and we'll answer it next time. All right, all-nighter. All right. Thank you guys very much.